Just saying this is where the rubber meets the road. All of this time that we've been talking about the origins and the architecture of intellectual property law is finally going to have a practical application today, because today what we're going to do is we're going to all learn how to file a patent application. Now, one of the things that we had talked about previously, and one of the things I wanted to go over and make sure it's clear, because it really does have to do with how and under what circumstances you file a patent application, is this whole Firstinventortofile thing that I've been asked about and we've talked about briefly. I think we've already mentioned that in 2001, the America Invents Act was enacted, and it is the most significant change to United States patent law since the statute was passed, the modern statute was passed in 1952. And after decades of debate in the United States, comparing and contrasting the pros and cons of first to invent versus first to file systems, the AIA switched the U.S. patent system from first to invent to first inventor to file. And the United States was one of the last countries in the world to get on board with first inventor to file. The AIA's central provision took effect as of March 16, 2013 for patent application filed on that day and thereafter. And so since everybody here is probably going to be filing their patents on and after that date, that's the important act that you're going to be faced with complying with. So first to file, what does it mean? So as we mentioned, the United States has long had a first to invent patent system in which the date of the invention could trump the date of filing of a patent application in determining patent rights. However, all that changed under the AIA, which was signed into law by President Obama in 2011 and took effect in 2013. For patent applications with an effective date of March 16, 2013 or later, the United States shifts to what is often and only partially accurately referred to as first inventor to file. The reality is a little bit more complex than that. These simple designations don't really take into account some of the most important aspects of patent filing. And so that's what we're going to talk about a little bit today. The AIA does not transform the U.S. into a true first-to-file system, in which the first inventor to the patent office, the one who wins the race to the steps of the patent office, gets the rights. This is because the drafters of the AIA retained the limited one-year grace period for applications filed after an enabling public disclosure by the inventor or someone who derived disclosure from the inventor. And this was added primarily to accommodate the early publication requirements and desires of universities and researchers and people who were involved in basic scientific research and development. So one of the things you have to keep in mind is that you've got to be very cautious, and that a delay in filing an application could result in the loss of your patent rights, even if the applicant, the inventor, if you are first to the patent office door. So how first to file, first to invent works. This is example number one. Consider the example of an employee in company A who conceives of an invention in May, works diligently to reduce it to practice, and then files an application for the corresponding patent in August, so 3 months later. And suppose at the same time, an employee from company B independently conceives of exactly the same invention 1 month later and files a patent application in July, that is, before the employee of company A, who conceived of the application, or the invention earlier, files the application. Under the old first to invent rule, company A gets the patent. But under the new first inventor to file, the outcome is a little different. If company A doesn't make any disclosures before the August filing, then company B gets the patent by virtue of its earlier filing date. And this is exactly what you'd expect under a first to file rule. However, suppose company A goes out to a trade show and the inventor gives a description or discloses the details of their invention. If you describe the invention in detail, and under the law that's called a disclosure, at a trade show or in some industry publication before a disclosure or the filing by Company B, in that case, Company A gets the patent even though it filed after Company B.
Is the definition of public disclosure defined in the law, or is that something yet to be litigated to determine what public disclosure constitutes?
It's defined in the rules, but even that definition is a little squishy sometimes. Maybe by giving you an example of a public disclosure, and because it's squishy, everyone is sort of agreed on what they're going to do. A public disclosure would be at a trade show, I have this great invention for these fins, and if I stood up here in front of 300 members of the sports equipment industry and described this wonderful invention that I had, that probably constitutes a public disclosure.
Yeah, just one person, I'm walking down the hall with someone from a company, and I tell them without any precondition of confidentiality, is that?
Probably not. Probably not, because the disclosure has to be public. But the real answer is it depends on the circumstances. Now, the way we get around that, and what I tell all of my clients, is file a preliminary patent application, a provisional patent application. And that really is even though they call it a provisional patent application, what it really is a public disclosure. And since 1998, the U.S. Patent and Trademark Office has allowed inventors to do that. And so in order to deal with this grace period and the squishiness of what a public disclosure really is, I mean, most times you can tell. If you tell somebody this is a secret, then it's not a public disclosure. If you stand up in front of 300 people at a trade show, that is a public disclosure. If you're walking down the hallway at MIT and you disclose something to a colleague in the context of an academic discussion, probably not.
What the MIT attorneys have basically said, when let's say you're in a research group and you give a weekly seminar, okay, just to your research group, that's not public. That's just for the research group. If you give a master's thesis or a doctoral thesis presentation, not the completion, but the proposal presentation, and you disclose something in that, those are announced to the MIT community, and that's public.
Right. And so your example of walking down the hall and saying, gee, I got this great idea, the answer is it depends on the context of the discussion. Are you having this discussion in preparation for your master's thesis or your doctoral dissertation? Or are you having this conversation just between two academic colleagues? You see, the circumstances can really make things squishy. So what I tell everybody, provisional application. Yes?
What's the difference between a provisional application and like a public, so say, like here we invent something today, we write a paper on it tomorrow, then we have like a year from the time that paper gets published or whatever. Right. At the end of that year, can you file a preliminary patent application to give yourself another year before the final?
No, you have 1 year, and it doesn't matter the form of the public disclosure. And you could be subject to a challenge if, for instance, you present a scientific paper detailing your invention, and then 366 days later you try to file a provisional application or even a patent. You could lose your rights in that sense. The difference between a provisional application and a public disclosure, such as in the context of a doctoral thesis, is simply the form in which the disclosure is being made. A disclosure is a disclosure is a disclosure. And the way we as, at least in my practice, what I tell people to do is if they're going to disclose, go straight to the patent office. Because the formality of that process actually imposes some technical rigor on the inventor, and it gets them moving. One of the things you can't do with patent applications is sit on your hands, because you're likely to lose your rights. So I send everybody straight to the patent office with a provisional application. Okay.
And a provisional's not that complex, you don't have to write everything.
That's the beauty of a provisional application. We'll get into it. I mean, you almost have to do nothing. And in fact, most provisional applications aren't even reviewed by a patent examiner. However, what I suggest people do is a little different than what is the minimum. But you can really get by with very little on a provisional disclosure. So here's example number 2, and I'm going to see if you've been listening. Company A receives and conceives of invention X on January 1st, 2013, okay? Company B independently conceives of invention X on February 1st, 2013, 1 month later. So a little bit like the old example I gave. Company B publishes a detailed enabling disclosure of invention X on March 1st, 2013, even though they came up with the invention second. Company A diligently files a patent application for invention X on April 1st, so 1 month later. Which company gets the US patent rights?
Can I ask a clarifying question?
Sure.
Does the AIA apply to inventions prior to the deadline or patents filed prior to the deadline?
Let's say the AIA applies to this example.
But is it, the AIA require that the invention be conceived of before it
No.
went into effect, or the patent must be filed before?
No, it's the disclosure, the patent, anything that happens after March 16th, 2013, the AIA applies to. Okay? So assume that the AIA does apply to this. That's exactly the first question you should have asked from this example. And the answer is AIA applies. So if AIA applies,
A.
That's it.
That's it.
did I hear B? Did I hear somebody say B? Here's the answer. As a result of Companies B publication of an enabling disclosure for invention X before Companies A patent application filing. Since Company A's patent application was filed on or after March 16th, okay, AIA applies, thereby falling under the first to file provision. Only Company B has potential US patent rights for invention X, even though Company A was first to file. This is the way that the US law differs from most first to file countries. Congress put this grace period in the statute to protect inventors and because universities and other inventors find it useful. But it's dangerous because it's an example of how the first inventor to file doesn't get patent rights if a competing inventor has made a disclosure. Disclosure controls. The clock starts ticking when the disclosure occurs. Company B must, of course, file a patent application within the 1 year grace period of its own publication, should it wish to seek patent application. Okay, so without the application, no patent rights. Yes.
So before March 16th, I guess doesn't apply anymore, but if there was a public disclosure, that would have carried on through past March 16th. So in this example, right? So before March 16th, it was basically first to invent or whatever, in which case it would have been Company A.
That's right.
But B made a public disclosure, which in the previous system might not have necessarily guaranteed them anything,
That's right.
right? So then, but because they made a disclosure under the new system, that carried through.
That's the magic event.
So would, if one company disclosed, would that start the clock on
Then,
them? But
yeah.
I guess also it would, if they disclose, that precludes anybody else from then making a claim, right?
That's,
Or
well,
Company
year.
B,
they can make the claim, but they're gonna get the rights.
that disclosure up front.
As long as they file their patent application. If they sit on their hands,
But then everybody loses it, right? If they say-
well, yeah.
Okay.
Everybody, yes.
So let's say, so B discloses March 1st. This AIA thing happens March 16th.
Right.
If A files sometime between those, they would get it because first to file is still,
Yeah, I guess.
if first to file is still, like first to, yeah, the rule hasn't changed yet.
Right. I think so. Thanks for making it hard. I mean, I don't know how many examples of that there actually were. Maybe back in March of 2013, there were a lot of them. I don't know. All right. The merits of first to file, who benefits? The merits of first to file system have been hotly debated. Many argue that the first file system will favor large companies with greater resources, but large companies have also more employees and they have, bureaucracies to deal with and lots of people and inventions, lots of departments, what to deal with. And sometimes small companies, or even better, individual inventors, are more agile, and they're actually able sometimes to see what big companies can't see, or if they see it because they're so large, can't act on it. And that way, the small inventor, under this act, I think is the greatest beneficiary. And so who benefits? The speedy people, whoever's first, whoever's fastest. Now, here's the downside of filing, of pre-filing disclosures. Pre-filing disclosures have a downside that wasn't changed by the AIA. We've already touched on this. It can eliminate the ability to obtain rights in the many international jurisdictions which do not recognize that 1 year grace period. Somebody was talking about a patent, competing patent in Japan the last time I was here. Japan, is one of those countries that does not have does not recognize this grace period for disclosures made in advance of a formal filing. And what has changed is that under first to file, silence can be more costly than before in obtaining U.S. patents. And under first to file, an inventor who does not take prompt action to protect their invention faces a higher risk of losing any rights to gaining U.S. patent recognition. And for this reason, the filing of a provisional application can be a cost-effective way of obtaining an early priority date for patent application. Let me repeat that, because if you come out of this class knowing one thing, you should know that sentence. For this reason, the filing of a provisional application can be a cost-effective way of obtaining an early priority date for a patent application. Provisional application, terribly important. So how do you file a provisional application? Since June? Yes.
Before we, so if Japan doesn't have the date, right? So you make a public disclosure in America,
Yep.
then somebody can come and patent right over the top of you in Japan,
Absolutely.
for example. So then,
Absolutely. Japan recognizes that.
so is there any? So what's the advantage of having that if you're looking at something large scale?
Well, the answer is it depends. I hate to
confirm my bias.
confirm your bias, but the answer is it depends. It depends on the jurisdictions. It depends on the market you're dealing with. And that's why we talked about all of the interconnectedness of these laws. It's terribly important to inform yourself of the markets that you're targeting and to know what their patent laws are.
So say, could I be, I don't know if it's being a troll or not, but basically watch the U.S. Patent Office, watch for provisional applications to come through, and then just file them in Japan? Because that doesn't apply. I'm not the inventor on it, but I can just steal everybody's ideas and file it in places where they go.
We should patent that idea.
Stealing other people's ideas?
I want to say yes, but I don't know. There's something about that example that
Because it doesn't seem right.
because I don't know enough about Japanese patent law, for instance, to give an answer to that. The answer
What about
would
like
be
European or something?
Well, I'm thinking of, I know one place, France. You're out of luck. So you could theoretically sit there and try to, steal stuff. But of course, you might not. The economic disincentive is you don't necessarily have patent rights in the United States. If you're interested in stealing them for another market, maybe. But patent rights,
if I stole somebody else's, they'd have to buy them from me if they want to expand it.
maybe.
So this is my new business.
Maybe. Okay. Well, see, now we have you. You're all set now. Good thing you came.
Building on that, though, wouldn't his disclosure in the U.S. service prior art? His prior art has no geographical boundaries, right? So wouldn't the SAM filing in Japan someone else's, Professor Eager's disclosure in the United States Service prior art.
That's one of the
And-
reasons why I said it depends. I would have to know what the definition of prior art was in Japan. Obviously, if you hired me, that would be one of the things that I would want to make a point of as your attorney in Japan, you know. So that's, you know, it's one of the things.
Just to give some historical context, the invention of, or the filing for the patent to make aluminum in the 1880s by Charles Martin Hall, who founded Alcoa, and Pétionnet, was it Hull? In the company they founded? Pétionnet was the company, but Haro. They call it the Hall-Haro process. They both of them did it independently. And apparently there was like a 2-hour filing difference back then.
Wow.
And I think it went to the Supreme Court, and Hall won, at least in the United States. But it didn't keep Haro from starting a company, because in the 1880s, Europe was sort of geographically separate. Today, you're not geographically separate. So today, Pétionnet wouldn't exist,
That's right.
because, but back then, the two of them grew up because of the Atlantic Ocean was in between.
Well, as you point out, that's not the case anymore. And patent and intellectual property rights are increasingly internationalized. And that's why we spend so much time talking about how this system, the architecture of this system.
Was there a question?
Was there a question? So, what is a provisional patent application? I told you to go out and file one. You know, what good is that advice unless I tell you what it is? So a provisional patent application is a type of interim utility patent filed with the USPTO. An application for provisional patent can be filed without including any formal patent claims, oath, or declaration, or any information disclosure, prior art statement. The key word in provisional patent application is provisional. A provisional patent applies only gives 1 year of protection. And after that, a non-provisional patent application must be filed with the United States Patent and Trademark Office. So you only have 365 days. If you wait 1 day, you've lost your rights. It goes into the public domain theoretically. So the USPTO created provisional patent applications as a means to establish an early effective filing date for non-provisional patent applications, which help balance the American patent law with the patent laws of other countries. And it also allows the term patent pending. So let me go into some of the details of what an application for provisional patent is required. First of all, there are no forms. And by the way, one of the things I wanted to make clear is that what maybe goes into a patent is rocket science, but the filing of a patent generally is not rocket science. And we shouldn't, as scientists and inventors and researchers, be afraid of this area of the law. It's the hard part is written by the inventor, the scientist. The patent application is very, very limited in terms of the formal legal requirements. There's a bunch of, so in other words, if you kind of compared what input the lawyers have in a patent application with the input that the scientists have, or the inventor has, at least in the way I advise my client, it's 99% inventor and 1% lawyer. And I say that because I don't want patent application to be a scary thing to you. It's a very matter-of-fact thing that you know all about, you just don't realize you know all about it yet. And it's just a matter of taking the idea that you and only you are best able to describe and putting it in a form which is acceptable to the patent office. So this is kind of an organizational thing. The hard part is done by the inventor. So as Professor Eager pointed out, there are not a lot of formalities required, especially with a provisional patent application. You don't have to have a declaration. You don't have to have a claims section. You don't have to have an abstract. You don't have to have detailed drawings. All you have to do is describe your patent, your invention in general terms, include a diagram if possible, a simple diagram, and describe what the object of the invention is. And that's about it. As long as you identify yourself and your name and address, that's basically all that's required. So parts of the application will need to be written by you or a professional, and you need to accompany the application with what they call a provisional cover sheet and a feed transmittal form. Most important thing is to pay your $125.
Typically, I know even if you have an attorney read it and stuff, you can do this for $1,000. I mean, it may be a $125 fee to the patent office, but there are attorneys out there who will, you write it up, they read it, they put the stamp on it, and send it to the right place. And so I was with a company, and they used to budget about $1,000 for every provisional.
Absolutely, and by the time you leave this classroom, you'll be able to save that $1,000 because you'll be able to put it all together. Anyhow, a provisional patent must include, okay, the specification or description. And that's just a written description of your invention. Very simple, not complex, not detailed. The figures or simple drawings. Just what that means is show what your invention looks like. The transmittal letter or cover sheet. This shows who the inventors are and who's filing the application. Not real complicated. One line. A provisional patent application does not need claims or formal drawings. This is one reason why it's much less expensive to file a provisional patent application. Cost of drafting claims and having sophisticated, detailed engineering or mechanical drawings is avoided. And there is some debate among legal scholars, and I don't mean to include myself in that group, but there is some debate among scholars about whether a claims section or an abstract is necessary in a provisional patent application filing. And I'm going to explain to you why I advise all of my clients to include such a thing. But while I do that, what I wanted to pass out to you is Professor Alex Slocum from this school has generously permitted me to, actually you two can share, and maybe you can share his provisional patent application for something that we all can't possibly do without. How you got along this far in your life without one of these is a mystery to me, and I'm sure once you read the application will be a mystery to you all. But while I describe to you what is involved in a provisional patent application, I'd like you to see what a real provisional patent application looks like and what a real invention looks like. Maybe make you in charge of passing things around. What you have is a provisional patent application filed by Professor Alex Slocum with the United States Patent and Trademark Office that concerns this invention called run fins. And if you look at the application itself, you'll see that it really is, except for the drawings, a very, very simple document. First of all, you have the specification of the description, the figures, or a simple drawing. In this particular patent application, the drawings and the figures are a lot more detailed than most, but I give it to you because there's a reason why I like this as a provisional application. A provisional patent application, as I said, does not need to have formal drawings, but there's a tremendous advantage to having these formal drawings. And one of them is that when you go to file your non-provisional patent application, this will be a big leg up on that process. Basically, all you have to do is take Professor Slocum's provisional application and add a section of claims, and you basically have the non-provisional application, final application that's necessary to be filed. You save a lot of money that way, you save a lot of time that way, and I find that it gets clients moving. One of the things that we worry about so much is that 365-day period. The simpler the application is in the beginning, and the more work that lies ahead of you, the more likely the chance is that that date is going to slip by and a brilliant commercial idea is going to be lost. So what I always advise clients to do is to provide what I would call a sophisticated provisional patent application, because that makes the rest of the process that much easier. Yes.
So they're called provisional patent application, and we're assuming, I think, that all of these are gonna get like approved. I'm not sure what the process is gonna approve, like how often they get rejected, or what would it take to reject it. And then if it does get rejected, wouldn't the application count as disclosure?
Wouldn't the application count?
Even
as
though you
disclosure?
didn't, even though you didn't get
Yes.
it passed, it went public.
Yes, and I can't remember when one got rejected, because many of
I
them,
mean, I guess your attorney isn't gonna let you turn one into something complete.
right, and quite frankly, the US Patent and Trademark Office usually doesn't examine them.
Okay, so it's just
Well,
like.
it's a placeholder. It's, you know, it's like, you know what it's like is when you run to a place and they date stamp your piece of paper. It's to mark the moment of disclosure. Because in the United States, what's the most important date? Filing or disclosure? Exactly. So this is a way of dealing with that disclosure. It's a formal way of dealing with the disclosure. But if you want to present this paper at a scientific meeting, fine. But if the scientific meeting is at 3 o'clock in the afternoon and somebody files a disclosure at 9 o'clock in the morning, who gets it? Under the AIA.
The first
The person who filed it a few hours before your disclosure. This more formal process has more protections, and that's why we recommend it. Yes.
So doesn't having like a much more detailed provisional or public disclosure also help you in the case of like my patent thief case? Because depending on how I disclose the invention, right, if I just call this aqua shoes for running or whatever,
Yeah.
had like
Excuse me, run fins.
No, if I just
Oh.
called them aqua shoes,
Right.
that had no drawings, explained there were 4 people running in pools, and that was it.
Yep.
There's almost zero prior art in that discussion. All I basically said is I'm making special shoes for aqua jogging.
That's
But
right.
since in Professor Slocum's example, he has like 95% of that document is drawings and descriptions of drawings,
Yep.
that is prior art, right?
Yes, yes, exactly. And as you point out, that's a real good place saver. If you've ever walked into like City Sports and looked at the aqua jogging stuff, if you took each invention and described it in its most basic terms, they'd all be the same. And so one of the things that I always advise people is to, really, that's why I never represent people, stupid people. I always try to represent smart people. The lawyers that taught me how to try cases taught me how to never lose a case. You know how that is? Never take a bad case. And with patent and intellectual property, never take a stupid call. Because quite frankly, the more detail there is in there, the more you know, the better off you're going to be, both as creating this placeholder disclosure and in the long run. As you can see, this application is 99% complete. You add a couple of sections, you add a claims section to that, and I don't think there's a claims examiner in the world who would reject this. Okay? All right. Basically, I've covered these things. A word about claims. Any non-provisional application for utility patent must contain at least one claim. Notice I said non-provisional. So a provisional application doesn't require a claims section. But one thing I always advise my clients to do is to put in a claim section, even just one claim. And the reason for that is, well, I'll explain. The claim or claim section must begin on a separate sheet of paper. If there are several claims, they should be numbered consecutively in Arabic numbers 1, 2, 3, 4, 5. See, I told you it's not really hard. And the claim section must begin with the statement, what I claim as my invention is, or we claim that, and then describe what it is that you claim your invention will do. And you include all of the claims that you can conceive of, including any derivative claims in that claim section. Now, once again, for a provisional application, I always suggest that they put in a claim section, and when they do the non-provisional application later, they can always augment the claim section. But it's always good to put in a claim section, once again, because it gives you a leg up on a non-provisional application, and it ultimately saves you money. Each claim should be a single sentence, and where the claim sets forth a number of elements or steps, each element or step of the claim should be separated by a line or indentation. It's just, you'll see a section in this application called objectives, and it's almost the same. Quite frankly, if you took the objectives section of this and put the words, what I claim as my invention is, you have your claim section. So that's a very good example of how a provisional application can be a leg up on a non-provisional application. The meaning of every term in a claim section is important, and I'll explain why this is in a moment. The meaning should be apparent from the descriptive portion of the specification with clear disclosure as to its import, and in mechanical cases, it should be identified in the descriptive portion of the specification by reference to the drawing, designating the part or parts therein to which the term applies. A term used in the claims may be given a special meaning in the description. And this is important because when the patent examiner sits down and tries to determine, based upon their review of the prior art, whether your patent, your invention adds anything to the prior art, and if it does, is worthy of protection. If the claim or description of the claim is not sufficient to distinguish it from prior art, you're going to get rejected, you're going to have to hire me, I'm going to have to negotiate with the patent examiner, we're probably going to have to amend your application, and it's like those old movies with the calendar, just flying by. Because the controlling date, and I want to emphasize this because I think I misspoke last time, the controlling date is the date of disclosure. That's when the clock starts ticking on your 20-year patent. So the more time that goes by wasting money on lawyers, negotiating with patent examiners, the more time it takes you to get that patent application. In the usual course, it's 3 years. And it can be much longer if I have to negotiate with a patent examiner, and then we have to file a amended patent application, and then that has to get in the queue with all the other amended patent applications. It can be a 5, 6, 7, 8-year process, depending upon the complexity. And you're losing money, you're losing the ability to market your product, you're losing the ability to license it, because nobody wants to wants a license on something that has been rejected. So it's important to get these claims right and to put as much detail into these applications as possible. That's why, even though you don't have to have a claims section, you don't have to have the kind of detail you see in that application, I advise my clients to do it. Because the clock is ticking, time is money when it comes to industrial patents.
I once had a patent attorney tell me that the patent attorney was the guy who ends up effectively I don't remember how he phrased it, broadening the patent. When they write the claims, the inventor will write down what they think they invented. And the attorney will often put in words in that claim that broaden it. They include everything the inventor did, but sometimes they end up inventing things by using broader words in the claims.
That's very true, and it brings up a very good point. I'm glad you mentioned it, because the attorney you choose is very important. While patent law is a subspecialty all on its own, it's broken down into mechanical patents, plant patents, utility patents, design patents, chemical patents, electrical patents. And so different patent attorneys often specialize in different subspecialties of patent law. And many of them, as you were saying, have advanced degrees, mechanical engineering, electrical engineering, or in biology. And so it's important to choose an attorney who can help you, not slow you down. When somebody comes into my office and they have something that's in the biotechnology area, I send them right to somebody who's much smarter than I am in that area. I'm not doing anybody a favor by learning on their dime. So what I do is I'll send you to the specialists, and important in the event that you have to hire a patent attorney, to hire somebody that is familiar with this area of your invention. And that means that when you sit down with them and you're sitting in front of the lawyer's desk, you ask them. And you don't get up out of that chair until they satisfy you that they have the expertise and the skill needed to serve your particular needs. You know, you can do a quick patent application on, what's it called, LegalZoom, or, you know, you can go to somebody and pay them $1,000. When you're dealing with major patents, where lots of money is at stake, you really need to make sure that you have the right person and spend your money wisely. Because, as I say, you don't want me to learn on your dime. You want somebody who knows much more than I do about that area, who doesn't have to be taught any lessons. So it's important to choose the right patent attorney and make sure they have the right background and experience in that particular area of invention or science. Abstract, you know, basically, has anybody written a scientific article? Or has anybody read a scientific article? The first thing you read is the abstract. Same thing for a patent application. It's 3 or 4 sentences that describes or summarizes your invention. And it's mostly used by the Patent and Trademark Office to do research. So in order to, for instance, in order to catalog this particular device in the library at the U.S. Patent and Trademark Office so that we can find it, it's under, you know, athletic equipment, fins, things like that. The abstract helps in searches of prior art, in searches of similar patents, and so forth. The cover sheet, you know, I'm not even going to go through it, but very quickly, the names of the inventor, where the inventors live, the title of the invention, name and registration number of the attorney or agent, if you have one, the correspondence address. And one thing that's very important is whether U.S. government funding has been involved in any way in the invention. You'll see on this particular application, that's the second thing after the title of the invention that I think Alex has in his application. And there's a form at the USPTO. If you have any interest in this kind of stuff, if it really comes down to it, and you're afraid to call me, then you can go online and you can get this stuff really easily off the USPTO website. The forms and everything are right there. Honestly, a monkey could do it. Duration of a provisional patent, then what happens? This is, I think we've already touched on some of this. As we said, the provisional patent application lasts 12 months. Therefore, an applicant who files a provisional application must file a corresponding non-provisional application within 12 months, or you lose your rights. The corresponding non-provisional application must contain or be amended to contain a specific reference to the provisional application. It's very important. And once a provisional application is filed, an alternative to filing a corresponding non-provisional application is to convert the provisional application to a non-provisional application by filing a grantable petition, but I never recommend that anybody do that. It is a possibility. I can't think of a single set of circumstances where you would do that, but that's one of the options that you have. And this is why I don't suggest that option. Converting a provisional application to a non-provisional will have a negative impact on the term of the patent. That's because the term of the patent issuing from a non-provisional application resulting from the conversion of the provisional will be measured from the original filing date. So you lose basically 12 months. That's what happens. By filing a provisional application first and then filing the corresponding non-provisional application that references the provisional application within the 12-month provisional pendency period, a patent term endpoint may be extended by as much as 12 months. So that's why you always refer back, because it's the protection that you're looking for, and the protection, remember, is retroactive. Protection begins the day you file your disclosure, the day you file your provisional application. Not when you get your application approved, or even when you file your non-provisional application. Protection begins retroactively to the date of the original filing. That's why you'd never convert, because you'd lose that whole year. Time limit, we've already really gone over that. Advantages of the provisional patent, we've already pretty much gone over that. It's simplified, costs less, establishes an official United States application filing date, which is really important. Provisional patent permits 1 year's authorization of the use of the term patent pending, which is very important. Begins the Paris Convention priority year, which is, the first to file that we talked about. Provisional patent enables immediate commercial promotion of the invention with greater security against having your ideas stolen. A couple of other advantages. Preserves the application in confidence without publication. It permits the applicant to obtain certified copies, which is very important when you're trying to market your device with somebody with a lot of money. Provisional patent allows for the filing of multiple provisional applications and for consolidating them. So if you have 5 provisional applications, you can consolidate them all into one non-provisional application. So I don't know, maybe you could think of 5 different versions of that Aquafin, or maybe you could, but I can't. But assuming your invention comprises the subject area of 5 different provisionals, you can combine them all and get protection for all of those retroactively 1 year. And it provides for submission of additional inventor names in case anybody has been inadvertently left off the list, which I'm sure no one would want to do. Another possible advantage is if you could succeed in finding good product marketers, a company that wants to license and manufacture your invention during that 12-month period, they'll often pay the upfront money. So they'll hire the big law firm. They'll fund all of the research that you need in order to do the final application. You can do a very fancy application usually on somebody else's money. And getting that provisional application approved really enables you to walk into somebody's office with a lot of money who wants to buy your device and get them to foot all the bills. And you just sit there and collect the licensing fees. Other advantages is the USPTO places an application in the queue. Now, this is important. I want you to understand how long it actually takes, although I touched on this already. First thing that happens is your application goes in the inbox of the examiner. The average wait time for an examiner is 24 months before the examiner begins the examination process. And after examining the patent, the examiner will then negotiate with the inventor's patent attorney during what's called the patent prosecution. And if the examiner and the inventor's attorney come to an agreement on the scope of the claims, the examiner will allow the application to issue. This is why the claims are so important, why they need to be described in so much detail, to cut down the amount of negotiation during the patent prosecution phase so that you can get on with the marketing of your invention. The average wait time from the date of filing to the issuance of a patent is 3 years, and that's optimistic. That assumes that the going is smooth, that there's no substantial negotiation, renegotiation, or amendment of the patent application, and therefore, in the average case, the patent will be issued about 3 years from the filing date. Again, really important if you're trying to attract money. We can go into this 2 steps. We'll talk about this tomorrow. I want to talk a little bit more about what a non-provisional patent application entails. Go through a couple of Supreme Court cases that will be important to you because they really are writing more patent law than Congress is these days. But we can go over that tomorrow. I have the evaluations, and I even finished a little ahead of schedule so that you'll be on time for the next class. Any questions?